Hello, everyone. We're here for our live webinar, Unlocking Business Immigration Strategies When All Else Fails. C10 Significant Benefit Work Permits. Thank you, everybody, for being here. Wow, we already have 100 people connected. By the way, we have more than 300 people registered. Around 310, I believe, was the last number I got. So we're probably expecting around half or a little bit more than that to be with us today. So thank you, everybody, for joining. As you know, I love to hear where everybody's coming from. Hey, Ken Nicolaine, thank you for being here. Binod, Toronto, Calgary. Ooh, Rocky Law saying that he loves Mark's videos. We're really lucky to have Mark today. Montreal. Yes, so as usual, we're going to wait for a couple of minutes to get started. For those who are here, please keep in mind that as soon as the webinar ends, we're going to be sending the recording. If you attended or registered, you will have the recording at the end, and that would be arriving on your emails, okay? Let's see, Toronto, a lot of people from Toronto, Montreal, Pakistan, Vancouver, Istanbul. Amazing. Hi, Phil Mooney from Burlington. Always happy to have you. Sohail, Sadegi, Taraka from Sri Lanka. Wonderful. Thank you, everybody, for joining. We know everybody's very busy, so we're really flattered by the fact that you're with us here today. As you know, we have a wonderful guest and also a very interesting topic. Unlocking business immigration strategies when all else fails. We're going to be talking about the C10 significant benefit work permits. Our guest is Mark Holthe. We're going to introduce him in a bit. People from India, Halifax. Okay. So we have 120 people already connected. So let's get started, shall we? So hello, everybody, again, and a big welcome to everyone who's joining us today for this webinar. We're grateful that you've taken the time out of your busy schedule to join us. And of course, we know that we are quite sure that it will be a time well spent. The title of today's webinar, as I was mentioning, is Unlocking Business Immigration Strategies When All Else Fails. We're going to be talking about the C10 Significant Benefit Work Permits, which is a topic that we talk about a lot with our partners and clients. And as always, we love to bring in wonderful guests that are here to discuss about those topics, lawyers, immigration consultants. So it's always a pleasure to have our wonderful guests in our sessions. I'm Marianella Mansour, the Global Director of Sales and Marketing here at Joorney Business Plans, and I'll be your host for today's session. A little bit of a reminder about Joorney. Some of you already know us, but for those who don't, Joorney specializes doing business plans for immigration. We have offices in the US, in Canada, in Australia. We have a wonderful team of more than 180 people, and we're currently preparing more than 6,000 business plans a year. We work with many different industries, more than 160 different industries. So the team does an amazing job. Specifically, our Canadian office specializes in various business programs. And today's focus is going to be about the C10 Significant Benefit Work Permit. So we're going to have an overview and some insights, also about other business immigration programs. And to help us navigate this topic, we are pleased to welcome a very popular guest who many of you probably already know. So he's going to be able to share his professional take on a number of aspects about the C10 and also Canadian immigration overall. His name is Mark Holthe. He's an immigration lawyer, founder of Holthe Immigration Law, and Chief Inspirational Officer at the Canadian Immigration Institute, where he also hosts an amazing YouTube channel full of great information and helpful advice. If you haven't seen it already, definitely check it out. He has great content, and you can find it on the Canadian Immigration Institute's YouTube channel. And that being said, I'm going to ask the team also to share that link on the chat so that everybody can subscribe to the channel. So despite being a very busy person, Mark has found time to join us today for this conversation. And for that, we are always very, very grateful, because this is actually the second time Mark Holthe is with us. So we're very grateful. And as Mark knows, back in 2018, we were featured on Mark's podcast when we were just starting. And I personally and the team, we will always be grateful for that. Welcome, Mark.
Oh, thanks so much, Marianella. It's my pleasure to be here with everyone. This is an interesting topic that we have, and here, in the firm Holthe Immigration Law and our marketing, promotional, kind of educational element, which is the Canadian Immigration Institute, we've got a lot of things going on. And yes, the podcast is still alive and well. I think we're just releasing episode 125, I think,
Wow.
this week. And we've recently started a business immigration series that we're doing that's working its way through all of the various work permit categories, including C10s and things like that. We finished a very comprehensive overview of the foreign worker program, all the ins and outs, and now we're working through the various treaty work permits and intercompany transfers and all those things. So C10 fits into the mix, and we will be doing another episode on this specific topic later. But yeah, the Canadian Immigration Podcast, I think I started that in 2014 or 2015. It was one of the first ones that kickstarted, and then I fell in love with video. So that's why the YouTube channel, the Canadian Immigration Institute, has got. In fact, Marianella, right now we have a live Q&A going on our channel right at this exact time with Alicia and Igor in our office, and so we're actually competing a little bit for the same audience. But I do recognize some of the individuals that have tuned in here that pop in and say hi on that channel. So it's great to have everyone here. And then, of course, with the Canadian Immigration Institute, we have our series of DIY kind of courses and master classes. And right now, we're really focusing on the core stuff: express entry, spousal sponsorships, and study permits. And so I know some of the viewers here have subscribed to those in the past, and I just want to remind everyone, the neat thing about those is once you buy it, you've got it for life. So the express entry, any updates, and any future master classes that you want to attend, you're eligible to, you can come and join as many times as you want. So I love doing that. If I could do this all day, Marianella, this is what I would do.
Amazing, Mark. You say that you fell in love with the cameras, but I think it was the other way around. No? The cameras also fell in love with you. Great. So yes, please follow the YouTube, subscribe to the YouTube channel for Mark. And then if we don't go through some of the Q&As here, you can always go there and ask them. And we'll be sharing also Mark's information so that you can reach out for sure. Just a quick note before we dive in. As many of you know, at the end, first we're gonna ask Mark a few questions about the C10, and then at the end we're gonna have a Q&A session. And if you have any specific questions for Mark, you can go on the questions tab and write your questions there, and we'll get to them at the end. Okay. Okay. Let's get started, Mark.
Perfect.
So can you provide an overview? I always like to start with the basics. Can you provide an overview of the C10 Significant Work Permit program and the types of projects or ventures that it typically covers?
Yes. Okay. So like the title states, it's a strategy that can be used when all else fails. So generally speaking, the C10 work permit is designed to avoid the need for a labor market impact assessment, at least right at the onset it is, although the instructions, and I'm going to encourage everyone, after this, make sure that you go back to the actual program delivery instructions that IRCC has for this work permit, just like they have for all of them. It was last updated March the 7th of this year, and there was actually quite a while where it had not been updated for a long time, and so some of the instructions were somewhat antiquated. But the main thing I want to focus is it is an LMIA exempt work permit, so it's through the International Mobility Program, and it's designed to grant work permits to individuals who can demonstrate a significant benefit to Canada under either an economic, a social, or a cultural basis. And the general instructions state that there, or some other competitive advantage for Canada, or that there are reciprocal benefits enjoyed by Canadians or permanent residents. And so it's interesting because there's so many different programs now within the International Mobility Program itself, so many different work permit categories that are very specifically defined. So you go on the list, you take a look, and you can see, okay, if I meet these requirements, then I'm going to be eligible. With the C10, it's not that way. It's very case by case. So some of you who've been in the practicing for a while may have tried C10s in areas that I haven't and had success. But the reality is, and this is the important note that's right at the beginning, the officers who are adjudicating these are specifically instructed, and I'm going to quote this, that it should not be used for the sake of convenience, nor in any other manner that would undermine or try to circumvent the importance of the LMIA. And so significant social, cultural, economic benefits to Canada are so clear and compelling that it overrides the need for an LMIA. So Marianella, that's kind of the basis for this. It's in a way, it's kind of like an H&C for permanent residents, if you're familiar with that. When there's no other permanent resident program available and there's sufficient humanitarian and compassionate considerations to justify the issuance of permanent residence, it's kind of like that for a work permit, where there isn't time maybe to get the LMIA. There's no other program that would fit, but the need for this foreign national to come here is just so compelling, and it creates such a significant benefit to Canada that they're willing to issue the work permit without the need for the LMIA. So that's kind of a high level overview.
Thank you, Mark. No, and we were talking about it before we started. I said it's everything, but it's not clear. It's sort of vague. And you actually answered to me and you said, yes, that's actually the case. So it is very vague. So to try to narrow down and try to take away a little bit of that vague to it, I'd like to ask you, what specifically does significant benefit entail? Like, what are those key eligibility criteria for people who are seeking the C10?
Right. So one of the factors that the officers, once again, I'm going to reiterate this work permit gives officers tremendous amount of discretion. And I'll get into some of the crazy examples that I've had using this, but it gives officers discretion to issue a work permit when normally there wouldn't be one available. So before the creation, I'm going to go back in time, before the creation of the employer portal and the registration, if an individual was coming from a visa exempt country and they arrived at the port of entry and the officer says, you're not a business visitor coming in for meetings, but they felt that the person was only going to be here for a few days, often they would issue them a work permit. And some of us who have been practicing, we always wonder, okay, well, what are they doing? How are they just issuing this person a work permit? They have nothing with them. But the officer would use that and be very liberal, especially the border service officers, in granting a C10 work permit for the person to come in, do what they needed to do. They'd pay the work permit fee, and it would only be issued for maybe the weekend that they were there. And so C10 was actually used quite a bit in the past. And then everything changed with the employer portal, because then an officer didn't have the discretion to just, issue a work permit. There would actually have to be a job offer registered. And so it really curtailed a lot of this. But the reality is it's case by case. And so you have to make the pitch. So what is considered to be a significant benefit? Well, they have some considerations in the program delivery instructions, and I'm going to go through those. But the key is to read them as illustrative. In other words, these are examples. And if you can argue that the similar kind of fact pattern exists in your situation, it exists in some of their examples, then you may just be successful. And so you're always looking for analogy. And that's really what you have to work with, because there's very few specific instructions. So it's interesting. You know, if you look at the CUSMA or the NAFTA, you know, the old NAFTA professional category, it says this is what you need, this. And if you look at what it says in terms of documentation to support this, it says detailed evidence of how the foreign national's work provides a significant benefit. Full stop. But I'm going to point something out. I'm going to point something out here. It says, note, a simple copy and paste from the department's website is not sufficient evidence. So you can't be lazy with this. This requires a lot of work. So even if you find a scenario that's very similar to yours, you never want to just copy and paste it into your submission. And like most of these work permit applications, the bulk of it, your arguments and everything you're presenting to the officer, I always include that in the employer's letter. So the employer becomes this unbelievably knowledgeable, employer on Canadian work permit processes, because their letter is where I build out all of my argument, and then obviously any other supporting documentation. So to start with, this is one of the things I want to reiterate again, that officers are instructed as a general principle. And the general principle is, once again, that authorizing a foreign national to work in Canada has an impact on the Canadian labor market and economy. So unless you can show that that impact is neutral or positive, then this isn't going to fly. At least not generally, it won't. Sometimes crazy things happen, and I'll talk about this in one of the examples a little bit later, a little teaser. But it says, in general, officers should be reluctant to issue a work permit without essentially an LMIA. So that's what you're dealing with. And that's why we say when all else fails. Because if you have the ability to get an LMIA, then you're going to have to get it. And unless you have a very good reason why, that's where, where you need the C10 maybe to bridge the gap until it's received. In some cases, you can make the arguments. And I won't go into a lot of detail, but they have unique situations specifically laid out where this work permit has already been kind of adjudicated, and there's a pattern of people that continually need it. Like, for example, on the economic one, and I've used this in my past, rail grinding operators and track maintenance workers. So companies coming in to service CP and CN rail lines across the country. I've used that one in the past where they've already shown that there's a significant benefit to Canada. What's the benefit? Well, what happens when there's a rail accident and the damage and everything that happens if the lines are not properly maintained. So obviously they say, okay, this is significant benefit. These people are only coming in for a short period of time. And I know, Marianella, we're going to talk about that as well. How,
yes,
duration of the work permit and duration of the project or whatever you're doing, how that can also play a role or impact in the issuance of these work permits. But let's just talk generally about the benefits. So what would be a significant benefit? So I'm just gonna pull these right out of the program delivery instructions, because this is your source and this is what the officers are going to be looking at. So you want to find analogous fact patterns that fit. So if your situation doesn't fit into one of these, it doesn't mean that you can't make the pitch, but this is what an officer is going to be looking at. So general economic support for Canada. So what is economic support? Job creation, right?
Exactly.
Or you're developing a new market in Canada, or you're expanding an industry, which is, the advancement of a Canadian industry, something new, novel, that isn't already here.
Exactly.
Yes. Yep, exactly. And then those are on the economic side. And then the social and cultural, increased health and well-being, increased tolerance, knowledge, or opportunities to come together with others of similar cultures. Never try to use one of those, but those are kind of general, overriding factors that they look at. But I think most people here want to know about the economics. So let's just talk about the economics a little bit. I'm just going to review the exact things that are listed in the program delivery instructions, and then we'll kind of breathe some life into them. So once again, at a high level, they talk about these benefits that would contribute to, say, a company's growth or expansion, and sometimes you have to read between the lines, it says, or continuation. Well, if you have an individual that's coming in that is so critical, if they can't get in, you're going to have to shut your company down. That's a pretty good reason for a C10, okay? And it says, and that have fiscal benefits and allow for the competitive advantage of Canada's business community. So you can see these patterns that are developing. A significant benefit is something that's not just benefiting a company. Well, some of my other workers are having to work multiple shifts and we're short this person and we want to bring them in as a food service supervisor at McDonald's, right? Because we've got staff shortages and we can't find a Canadian to hire. That is not going to cut it. It needs to be not only a benefit to the company, but benefit to the industry or something larger. Now, I shouldn't say that that's a hard line, because yes, if you can show that bringing in this individual is going to create jobs for Canadians within the company, well, that's a benefit to Canada, right? Employing Canadians, even though it's your company that needs the workers, and by bringing this person in, maybe they have a unique skill set or a unique training that isn't available in Canada. And you can see some of these buzzwords that are overlapping with other areas like specialized knowledge within intercompany transfers, right? So there is this, and what's the reality? These are all under 205A, right, within the regulations. And so that's why intercompany transfers are within here. But they all fit within the Canadian benefits. That's the general, overarching umbrella that they're under. Okay. So now it says documenting evidence. I'll get into these last little bits, and this is really all we've got to work with, and then we'll expand into more specific things. But what is going to prove significant economic benefit? So preventing disruption of employment, right? If Canadians are permanent residents are going to lose their jobs, negotiating this big transaction that would benefit the Canadian economy. I don't know, maybe we're trying to maybe in the early days of Amazon deciding to set up big facilities in Canada, there was an individual, a Canadian company had hired to help with the negotiations to lure them to come in, right? Maybe that's a factor that would benefit. Advancing Canadian industry, preventing a disruption to a major Canadian event. This is kind of on the social or cultural side of things. But an event could be just about anything that employs people. So if the event isn't happening and all of these people were hired to run the event and they're all going to lose that opportunity, well, and what is an event? It's not defined. So that's where you have to use your creativity. And then of course, like we talked about, just job creation or skill transfer of skill or knowledge, which are also pillars to the LMIA process, right? So this is, a general economic stimulus just itself may or may not be enough, but they add economic stimulus to rural areas. So if you're making a pitch for a small little town in rural Ontario compared to Toronto, you're going to have an easier time showing significant economic benefit in a small rural location than you are in a larger city with the same fact pattern. So keep that in mind as well. So that's kind of just to get, whet people's appetites a little bit for it. Yeah.
So a lot of creativity on the immigration strategy side of things, right? So, I mean, I can imagine how tough it would be for an applicant to do this on their own. I mean, they need that edge and creativity coming from the immigration professional, being able to navigate those analogies between what's written and what can be argumented. And of course, I think the underlying base here is that you need to show that this is adding. These are opportunities that are being created, but you're not taking anything away from the labor market. You're not going to take a job from a Canadian. So I think that's like in summary what it's all about, right?
Yes. Yeah.
I wanted to ask you, Mark, how does the C10 specifically differ from other temporary work permits, and what advantages does it offer?
Yes. So the interesting thing about a C10. Okay, so let's touch on the C11 kind of C10 dynamic. So, for example, let's take a step back and let's actually look at the 204 the 205A provision, R205A, Canadian interests. This category encompasses a ton of different work permits that I think many of you are familiar with, right? So we've got those unique situations that we talked about, like the rail grinders and airline personnel and foreign physicians coming to Quebec, like all of those fit within unique situations for C10. But self-employed business owner, that's the whole C11 category. Intercompany transfers, C12, those fit within this same 205A. And then, of course, the Francophone Mobilité program fits within here. Even bridging work permits fit within this particular category. And so Canadian interests is the overarching kind of heading or factor that's being assessed. And then 205A is all about significant benefit. So, there's similarities, and think of it this way. When you're trying to determine if C10 is the right fit for you, you're going to go through everything else to see if they qualify or a person fits within it better. And one of the most important factors when you're looking at the comparisons between this, unlike C11, where it's for, like I said, self-employed, entrepreneurial kind of category, that is really not facilitative in any way for permanent residence. Whereas C10 is the same as any other employer-specific work permit that has eligibility under, express entry for the job offer because it's an employer-specific work permit. There's no necessary caps on the work permits, but we'll talk about duration a little bit later. And it's really designed to facilitate the issuance of a work permit where there are no other options and where an LMIA may not be possible. And this is a good time to add in just this whole, how it fits in with a labor market impact assessment. So the default rule is you always need to get an LMIA first, okay? And if the LMIA just doesn't fit, the timing is such that, say, this event is happening or this big project has deadlines that have to be met, and these individuals coming in, if they can't come in on time, it's going to delay the whole project and cost millions and millions of dollars. And even people may be out of work while they're waiting for this individual to come. So those type of big, large scale projects are ideally suited to these types of work permits, these C10s, because you don't have time to sit around and wait for a labor market impact assessment for however many business days they're advertising, for processing times for LMIAs, and then get a work permit on top of it. So so the C10 is just super broad, whereas the other work permits, like an intercompany transfer, you've got the person has to have worked for you for a year before being transferred. So that's really the main thing. It's as creative as you could use it, as you could want. I'm going to bring in one other thing too, Marianella. As we see with many of our clients in Canada, where permanent residence is just not happening for them, their work permits are expiring. Sometimes people study for a year and then they get a 1-year postgrad work permit, but they don't get their job until, a month into that work permit, and they're not going to have enough time. And so everyone knows that when you submit a work permit application, that the person can continue working under now maintained status until a decision is made. Well, what kind of work permit are you applying for? And most people just submit, the 5710 form and the application and knowing they're going to get it rejected. Well, I never, ever do that. And I feel that's almost unethical to do that. What I do, though, is I try to make a C10 argument, because then it's at least a legitimate work permit you're asking for. Now, what are the odds that it's actually going to get approved for a food service supervisor at McDonald's? Probably pretty low, but at least it's a legitimate work permit that you're asking for. And if it gets rejected, well, it's rejected, on its merits or lack of merits. So that's kind of a little bit of an overview, Marianella, of the differences.
Thank you, Mark. So you were mentioning like the differences, and you mentioned some of the eligibility criteria for the ICT. You also mentioned self-employed. But if you're an immigration professional working with the ICT and the self-employed, how can you benefit from the C10 for those clients? Yeah,
it's pretty simple. If you have an option to use an intercompany transfer work permit or anything else, you're going to do that first. You're not even going to consider C10. So a C10 is only something that you consider after exhausting all those other avenues. And one of the main ones that I use C10s for is when I can't get an LMIA quick enough. I'm still going to make the attempt. I'm still going to start the advertisements. But rather than filing a work permit application and then still waiting for it to be processed, I will consider, if the facts align, I will consider filing a C10 to bridge the gap until the LMIA is obtained, often maybe only for 6 months. And this is where the duration comes into play. So if you're in a situation where an LMIA is possible, but there just isn't time to get it and the person needs to start tomorrow, if they're coming from a visa exempt country, then that's an application that can be submitted right at the port of entry. And I'll be honest, I actually like to apply for C10s at the ports of entry. Now, people are probably going to ask, well, which ones are better than others? Well, I focus on the ports that have a higher volume of these types of business immigration applications. So do I send individuals to do a C10 at a border? No, I don't. And that's across the country. I'm not just talking about Sarnia and Coutts and the more difficult ports of entry. No, I'm talking about never do I send a C10 to be adjudicated at a port of entry. And yes, there is, you can get those temporary foreign worker opinions through the unit before you apply if you're visa exempt, if your client is a visa exempt individual. But I even try to shy away from those if I absolutely, if I can. I will go to the main airports, and generally speaking, Toronto and Vancouver's who I send these to. So just a little practice tip, because they're more used to seeing these types of applications.
Mark, and you were mentioning the importance of the duration or like nature of the project. You also mentioned that for the C11, it's very seasonal, very temporary, and that's very clear. But what about the duration or nature of the project in the case of the C10? Like, how long should it be? Is it still vague? Should it be supported as part of the application? Can you tell us more about that?
So if you are bringing someone in for a specific project, then I request the full duration of the project. So if you can really show that the individual is going to be working, the work that they're going to be doing is integral to the successful completion of this project, then I have no problems asking for a year or more for a C10 work permit. But here's the thing, there used to be language in the old instructions that specifically stated that C10s are really to be used to bridge the gap until a person gets an LMIA. And ironically, it's not ironically, it's basically been softened a little bit as far as I'm concerned in these newer program delivery instructions. And so when it comes to duration, it's easier for an officer to see, okay, the overriding need for this person to be here, the immediacy justifies that we get them here right away. But if it's a position where you really should have applied for a labor market impact assessment, but then in that situation, you're likely not going to get away with saying, well, I need the person for 2 years. They're going to say, well, I'll give you 6 months and go get an LMIA. And so it really is from that standpoint, if the duration is shorter, your chances of getting that work permit approved are higher. But it's really a gap that you're trying to fill until you can get that LMIA.
Okay, and Mark, I'm going to go ahead on a question that I had a little bit further along, but it has to do with this. So people who get a C10 work permit, it depends, of course, the projects are going to have a different duration. But because of the duration, then that would open a potential pathway to transition to permanent residency.
Yeah,
correct? So
absolutely.
in what cases would that work, and how does that transition look like?
Yeah. So, I've had border officers do all kinds of crazy things at the airport. So I had an individual that I asked for a 6-month bridge, C10, in Toronto so that this CEO executive could fill the role. There was major projects that this individual was running. And the border officer gave that individual a 3-year work permit. Okay, without me asking. They just gave them to them. And that was loads of time to get permanent residence. So we didn't need to do anything else. We started the process, and it's an employer-specific work permit. It's clearly skilled. I don't think, and that's another factor too. It's going to be a whole lot harder to demonstrate significant benefit with, even a tier 3, although you could make the argument, but tier 4 or 5, those lower skill occupations, it's going to be a whole lot harder to get that C10 for those than it is, obviously a more specialized role. So keep that in mind. But for that individual, the officer issued it for 3 years, and it was plenty of time, and we made it work. But always remember that you never want to just rely on it. If it's issued for 1 year, it's just not going to be enough. You have to be able to extend that permit. And sometimes the whole argument that you're basing in getting that initial one is the urgency and the fact that you need them there right now. And remember, as we've heard, probably you've heard in other webinars and other immigration lawyers say, and having worked as a border officer, I want to phrase this right. Your poor planning doesn't constitute my emergency, right? So this is what the officers say. So it's not like you can keep going back to the well on this if you have other alternatives. So keep that in mind.
So what would an extension look like? I mean, of course, it's going to depend on the project, but it's basically argumenting strongly that person needs to stay, but it's no longer urgent. It's more like I need more time.
Well, there could be a number of different things. Like the project could be delayed, right? So even though they came in, everything's delayed and we still need the person. We weren't anticipating it. That's why we didn't apply for a new labor market impact assessment, because we thought this 1 year that you were so kind to give us, officer, would have been loads of time because the project was supposed to be completed in 7 months. But there's been, delays, materials were delayed. There were problems with this part, and this person still is filling an absolutely critical role. And if they have to leave mid-project, or we have to then have them stop working to get an LMIA, it'll cause all of these disastrous consequences to everybody, right? So that's kind of how you would approach it.
Mark, and you mentioned a few stories that you've faced with the C10. Can you tell us examples specifically on the economic impact? We would love to hear your success stories.
Okay, so sometimes I'll mix in social and cultural too with my economic if the economics are not as perfect. So my favorite one was actually fixing a mistake that happened in our office. So we had filed a spousal sponsorship for a couple, and we'd submitted a church marriage certificate and not the formal civil one. And it looked so official from that country. I didn't know that it was just a religious one. So anyways, this person, it was an in-Canada application, and we included an open work permit with it because the spouse that was being sponsored was working. In fact, her husband had bought her a tanning salon, and she was the manager of the tanning salon. And, it was a small little tanning salon in West Lethbridge, and they employed 2 part-time people as well as her. And so when it got returned, she had to stop working, and I was freaking out. So what did we do? I prepared a C10 application for her and was able to convince a border officer at the Calgary airport that her role created a significant economic benefit to Canada. Now, they had, there was the 2 jobs. If she had to stop working, then the 2 part-time jobs, the business would have to close until she got another work permit. We'd have to apply for a labor market impact assessment. And then I put in a whole bunch of other things, including, volunteer work and contributions they'd made to the university, and all these kinds of things. And so it's just a matter of creativity. So that's one example. There was another example of someone who had, I can't remember, it was some very, very rare skill set. I'm trying to remember, what was it? It wasn't quite artificial intelligence, but it was working towards that. And this unique IP that this person had, this company had recruited them specifically for this purpose. And they knew they needed an LMIA, but they needed the person to start right away. And that was, I think, in Ottawa, we did that. And we did it through the airport in Ottawa. And we made the pitch. We only asked for 6 months because the person really needed a labor market impact assessment, but they were a new hire. And then we made sure the LMIA was moving forward as quick as possible. And the 6-month C10 was issued. So those are just 2 examples kind of on both spectrums. And I'm sure people have seen, before the employer portal days, anyone who showed up who could make a business case, the border officers, and especially the airports didn't want to put a business person on a plane and ship them back. So they would, these short little term C10s, they were more than willing to grant. And this was before our 15 and 30 day, little entries that the government allows now for business personnel. Yeah.
Exactly. On our case with the business plans, of course, we don't always have visibility of whether they were approved or not, right?
Yep.
But we've seen a lot of the rural cases of where, like, depending on the communities where they're located, they impact economically, but also socially and culturally. So we've had businesses that seem to be simple and are not, maybe you would think that they're not a significant benefit on their own, but as long as they are very argumented as to the location, the specific culture that they're aiming for, it could be anything. So
The
that would
grocery
include a
store,
restaurant or a
right?
grocery store.
The grocery
Exactly.
store in a small, and I grew up in small, like the town that I grew up in, I lived on a farm outside of a community that had 200 people. So we were about 70 kilometers to the nearest larger town, which was Lethbridge, at the time was probably 65,000 people. So yeah, a grocery store, and this is why I said in terms of the economic benefits, it's much easier to show it in a rural area than it is in a large, metropolis. And so you just make the case, if the grocery store has to shut down, then they have no grocery store. They have to travel an hour, wherever to get their groceries. So that's the foundation.
And overall, Mark, what can you provide some tips on how to navigate the complexities of the C10 to increase the chances of success for the clients?
Yeah. So right at the beginning, it says, don't copy and paste. Okay. So don't copy and paste the actual wording that they include from the program delivery instructions. Don't just copy and paste that into an employer letter, but you do want to, create, an analogy to your situation and tie it back to the same principles that exist within those instructions on the program delivery, the PDIs. So you want to be very, very careful to pull in those analogies to the examples that they've set, and to really, really emphasize how there is economic benefit or spin-off. Sometimes I like to, if it's a larger project and it's benefiting a community, well, I want to get a letter from the Economic Development Association or from the municipality explaining how this project is going to benefit all of these people. We've got this directional drilling project where it's for a water pipeline that's going to bring water to the community, things like that, or expand because of the growth in the community. But wherever possible, third-party entities that can also attest to the benefits are huge. Those are huge. And you really need to emphasize how this person is going to themselves, their presence is going to create this significant economic benefit. So those are, the main points that I would point out are just really trying to draw analogies to what IRCC has in their program delivery instructions. And why do I keep saying that? Because not all officers are super sophisticated. And if they can see, and you can draw the comparisons to their set examples they're looking at and say, this is like this situation here, and this is why this is a significant economic benefit, then that's exactly the emphasis, and that's how you want to strategically develop these applications. Yes.
Okay. Thank you, Mark.
You bet.
Mark, do you see me right now?
I don't.
Yes. Okay.
It says bandwidth problems, but that's not a problem. We can hear you.
Okay. Good. I have a great list of questions. So if you're okay with it, Mark, I'm going to start the Q&A.
Let's do it.
Okay, great. Okay, so I have a question from Phil Mooney. With the likelihood of seeing large number of startup visa refusals for people already in Canada with an operating business, would you recommend C10 SUV refusal based on a negative peer review or loss of a partner or change in approved business?
Yeah. So the principles, the beauty of the C10 is It's there when all else fails. Now, here's the thing. If someone applies for a labor market impact assessment and gets the LMIA rejected, well, in that situation, it is going to be very difficult to make the case for a C10. I'm not saying impossible. Maybe there's some unique fact scenario or something like that comes into play. Maybe the LMIA was refused because of an error or a mistake that could easily be corrected, but the timing is such, you need the person to start working right away. Maybe that's an example. But yeah, Phil, literally, it is a tool in your toolbox, and if the facts line up sufficient, you can absolutely make that case. You can. It's hard with a lot of these different programs. Any good program, I swear, gets abused to the point where then they start to wonder if they really want to continue with the program. And startup visas are no different from that. And so you get these officers formulate these opinions on these types of applications, and then it can somewhat color their willingness to issue, for example, like what you're experiencing in the world of startup visas. So is a C10 possible? Absolutely it is. It's within the Canadian interest, and you just have to demonstrate the significant economic benefit.
And I guess also highlight the jobs if there are also people working in that particular business.
Absolutely. Yes. The things that we've talked about, are people going to lose their jobs? Is the business going to shut down? Those are key factors that are at play. And with a lot of the startup visas, there's always, well, I have to assume there's always, transfer of skill and knowledge with, any type of a business that's really unique, that's cutting edge, that's bringing in new technology, or, just it's a novel industry, or you're expanding an existing industry within Canada. Those are the foundational pillars of the C10 work permit. So these are right at the source of what IRCC tells their officers to look for. So, and once again, it's case by case. You could have the same scenario presented to two different officers and get two different results. And that's just the nature of the discretion.
Mm-hmm. Definitely. And also along the lines of continuation, there's another question we have from Amy Nguyen. Can we make C10 case for someone who wants to acquire a business in Canada? If not, the business will have to close.
Well, once again, can you make that argument? Absolutely, you can make the argument. When it comes to this, remember, they're always looking to determine if an LMIA is a more appropriate route. So yes, once again, a wonderful program, the owner operator, right? And then it got freaking destroyed because of abuse and lots of people that were trying to wedge things in that really didn't fit, and then fraud. And I sat in so many meetings with when I was the chair of the CBA immigration section, and fighting with them, trying to get them to realize, look, this is an excellent program. You were going to remove a phenomenal program because of a few bad actors. I got the sense that there were more than a few, and that's what pushed them to close the owner-operator ad exempt. But the reality is an LMIA for an owner is still possible. You just have to advertise for the position, right? And so they're still going to push you back to the LMIA. They really are. And remember, even within the context of an LMIA, back in 2002 when IRPA was created, and they developed the factors that were required for securing a labor market opinion in those days, now an LMIA, all of the factors, none of them was really supposed to be given special treatment. A neutral or positive effect on the labor market was always there, as well as transfer of skill and knowledge. That was a factor. But unfortunately, demonstrating that there's no Canadian to fill the job just took over and became the factor that they're looking at. So they're going to be absolutely loath to issue a C10 if there's a possibility of getting an LMIA. Mm-hmm. So can you make the case? Well, if you can make the case, you can try. And the reality is, if a C10 is refused, what's the default? An LMIA.
Exactly. Mark, we received a lot of this question repeatedly when people registered, and I know you touched on it when we started, but I would love to go in detail again. What is the difference between a C10 and a C11?
Yeah, and the difference between a C10 and a C11, there's a couple main key things. One, The C11 work permit, it's broken down really into the two categories, right? So, and I'll read straight from the program delivery instructions. Foreign nationals who seek entry to Canada as business owners. Okay, that's one of the main differences. C10 is you could be an owner and use C10. You could, so it kind of encompasses a little bit, but C10 is really as much about anyone who's coming in to work for a company as an employee and is providing significant economic benefit to Canada. Okay, so those who only seek entry for a temporary, and you can see here in the program delivery instructions, usually seasonal purpose to run their existing business if they're self-employed, and those who seek to start or run their business to meet the requirements of a PNP, or as an entrepreneur, or for federal startup business class, right? So this is kind of how they see C11. So C11 is much more narrow and for business owners, and C10 is wide open as long as you're hitting on the significant economic benefit. So that's really the difference between the two. One other thing I'll point out, obviously, if it's for entrepreneurs or business owners, you're going to have a really hard time claiming that Canadian work experience for the confirmation for the Canadian experience class. And that's one of the reasons I never do C11s. I just don't. I find other pathways. And then, obviously the C10, like I said, it's open. It's not restricted just to business owners. And C10 works 100% perfect for pretty much any provincial nominee program that is based on a job offer for express entry after they've worked for a year. So that's the huge differences.
And would there be any differences also on the side of the duration? Like, is it more seasonal and temporary on the case for C11?
Yep. Yeah. Just like the program delivery instructions state, they developed these preconceived ideas or notions about this. So they've already kind of gone out of their way to say, hey, unless you're seasonal, you're going to be hard pressed to seek a 2-year work permit under the C11 category, right? The goal is to get in, do your thing, and then get out. That's really what a C11 is about. Now, I'll give you some examples, some specific examples. If you go to the C11, what do you see there as those unique circumstances? It's like people who run a fly fishing shop, or fly fishing guiding trips in Canada who have Americans coming up, or a hunting guide. Those individuals, it's very seasonal, a short period of time. The foreign national might be a U.S. fly fishing guide or a U.S. hunting guide who does waterfowl hunts in Canada, and has a whole bunch of Americans who come up and hunt in Canada and inject hundreds of thousands, probably $1 million into the Canadian economy, millions of dollars, for a short period of time. So you can still see those benefits flowing economically, but those are some of the ones that are just recognized. And so there's more specific instructions on the C11 side, but that's really kind of what they're focusing on.
Okay. Thank you, Mark. We have another question. Well, you were actually talking about this. It's a question from Matt G. Any merit in trying to fit entrepreneurs into the C10 category instead of the C11? Noticing a lot more refusals and obstacles to getting a C11 following the updates to IRCC policy.
Yeah, I get it. Exactly. And this is always the case, isn't it, you guys? Once one beautiful program is ruined, then you have to find a place for those people to go. And there was a time, and I know immigration is getting back to there was a list of occupations where you didn't even need to advertise back in the early days, right? And then over time, abuses resulted in the shutdown of that program. And this is what we're seeing with the startup visa. There's just been enough abuses where immigration feels like people are not genuinely qualifying, or they're not really satisfying the purpose behind the program. And think of it this way: how many of your clients would apply through the startup visa program if the CRS scores for express entry were around 400, and that was the pass mark, right? So when we don't have the ability to get our clients in through, the traditional, federal skilled worker program, then we look at other avenues. And so for whatever purpose and whatever reason, IRCC is now seeing these as being areas where there's fraud or abuse of the program. And so then they start taking these more drastic steps to cull these types of situations. And it's awful because then you and your clients are affected by it. So is C10 a possibility? Well, if there's nothing else and you know that these other work permits are being shut down, then absolutely, I would take a run at it. That's why it's there. But is it easy? And I want to reemphasize to you guys, this is when nothing else, when all else fails, yes, consider a C10, but it's that way for a reason because there are no other options. And then you do the very best that you can to make the case, just like an H&C.
Exactly. I have a question from Jambavan. Once an LMIA application is approved, what type of category of a work permit application should be submitted? Should it be a C10 or something else?
Okay, so just to clarify, so a labor market impact assessment is the work permit category under the Temporary Foreign Worker Program. So if the LMIA is approved, then you are applying for a work permit that is authorized because you have secured a positive LMIA confirmation. So it's the LMIA confirmation that results in the issuance of the work permit. The C10 work permit and all of these other types of work permits are LMIA exempt. So in other words, you don't have to get an LMIA because you meet the requirements of these various work permits under the International Mobility Program. So if you got an LMIA, congratulations, that's awesome. You just apply straight for the work permit based on that LMIA confirmation number. I think that was the question that was asked, right, Marianella?
Yes, correct. I have a question from Ramin Kodai. How can we get a PR for persons after the work permit with C10 exemption? They are working for their own company, especially persons in Quebec who cannot benefit from federal programs.
Yep. So when it comes to any individual who's running their own business in Canada, unless you have already started down a path that allows for them to use that self-employed or entrepreneur, like through a PNP or a provincial program, you're going to be really, really hard pressed. So if an individual, and I advise my clients all the time, do not, even if you're on a post-grad work permit, unless you have a very clear pathway to PR, I never advise them to start up companies or anything until they get their permanent residence. So in that situation that you've described there, it's going to be really, really hard pressed. Now, I do not practice Quebec-based immigration, so I can't speak to the options that might exist within Quebec itself and the immigration program. But for the federal programs, there are very, very few exceptions for people who are self-employed to go through. They've recently carved out a little bit of an exception for physicians and doctors who really are self-employed and contracted to the health regions. So they've carved out an exception for them within the Canadian Experience class, the federal programs. But unless you're outside of Canada, entrepreneurial or self-employed work experience, it won't work.
Thank you, Mark. We have a question from Alexandra Klein. How friendly is the International Mobility Workers Unit to C10 assessments? Is it worth it, or is it too big of a risk and better try it at the port of entry?
Beautiful question. Thank you for asking that one. I avoid them like the plague. I just don't use them. I would rather take my chances with a border officer at an airport than have the unit, the International Mobility Unit, assess one of these. They're going to be far more strict, just like overseas visa offices are, right? They have more time to look through things. They can be pickier, versus someone who's standing right in front of you and you're adjudicating their work permit. But your job, if they do have the ability to apply to port of entry, which if you're asking about the international mobility, that unit, it means they're visa exempt. And so they can apply directly at the port of entry for the work permit. I always roll the dice and take my chances at the port of entry, advising my client that there's no guarantee and that they very well could have it refused. But I prefer to do that. Now, if your client is just risk averse and they say, you know what, I can't do it. I don't want to spend the, $1,500 or $2,000 for a flight to Canada only to be returned, then you can go through that process. But you have to, in my mind, you really, really have to well, not that I'm saying right now you can get by a C10 without providing a ton of evidence, but it's even more so for the international mobility program units. Yeah.
Interesting. We have a question from Rita Bencalti. Hi, Rita. Thank you for your question. Self-employed PR applications are taking over 4 years to process.
Yeah.
Although C11s mention self-employed people, can we use C10s to request a longer work permit for the applicants waiting on their self-employed PR to start operating in Canada?
Yeah. So this really comes down once again to being able to demonstrate case by case. We've talked about the factors that they're looking at. And so can you? There's nothing stopping anyone from submitting a C10. In fact, as I indicated before, people that are running out of time and they just need a couple extra months, I'll put together whatever C10 arguments I can for a food service supervisor at McDonald's to make a legitimate work permit application. Even though, it's a weak argument, it's still an argument, it's still a real program. But in your situation, you just have to make the case, right? And what are some big factors? Like if it's just you, self-employed, remember, many of the work permit categories are not designed for people to hang out shingles or just to work without having the intention of creating economic spin-offs to Canada, like hiring Canadians. So if an individual is truly self-employed, has no Canadians working for them, I think the argument's going to be tougher than someone who says, if I can't get this permit, I'm going to have to fire these 3 Canadian workers, and job loss is very persuasive for an officer. So you just have to make your case. Mm-hmm.
Great. I just wanted to tell everybody we're 2 minutes past, but we're going to stay around 1:15 to make sure that we get across some more questions. So we still have 153 people connected, so we're going to stay.
Sure.
If that's okay with you, Mark?
Absolutely.
Great. We have a question from Karen. With C10 refusal, is it a negative factor for future LMIA work permits? C10 is filed to gain early entry while LMIA is in process. Will low language ability cause C10 work permit refusal for senior IT manager position?
Okay, so that's a great question. Let's start with the first one. Will a C10 negatively affect an LMIA? No, it won't. Because what they're saying is, you're not eligible for this exemption, go get an LMIA. And so there will never be a situation where applying for a C10 will negatively impact on the actual LMIA application. Now, even in the case of an overseas visa office, if you apply for a C10, as you all know, one work permit refusal is going to make it more challenging when you apply a second time. And so that's a reality, but it's a pretty easy argument to make. Hey, we applied for the C10. They said it wasn't approved. And the refusal letters often say, go get an LMIA. And so you're just following their instructions. So I think it would be a reviewable error if an officer rejected an approved LMIA-based work permit after a C10 was rejected. I think that would be a reviewable error that you could file a leave application on that decision if it was based solely on the fact the C10 was rejected. Okay, and then what was the second part, Marianella, to that?
C10 is filed to gain early entry while LMIA is in process. Mm-hmm. Will low language ability cause C10 work permit refusal? Yeah.
Well, you guys have seen, I don't know if some of you saw the recent federal court case where a work permit application, it was even LMIA based, was rejected. And I think the person had a CLB5. So they're looking at language, and language is a factor with all work permits, LMIA based or otherwise. The person needs to have sufficient level of English to do their job. Now, when based on your occupation and the person, like in the tech industry, if it's computer programming or whatever it might be, it just comes down to you making the case. But language is still a factor. To what extent it would be a factor? Well, like I said, every situation is a little bit different, but clearly a language ability is something that, at least a base level, it's going to be something that you're going to have to argue for and justify if it's low, if the language ability is low.
Okay. Thank you, Mark. We have a few more questions. Svetlana asks, C12 work experience. Do you see any problem with Canadian experience claimed in the express entry after 1 year of employment? Also, C10, the experience cannot be claimed, but job offer can. Is it so?
Okay, so just to clarify, C10, if the person is not self-employed, right, and they're not in a role where they would consider them to be self-employed, like an independent contractor, if they're an employee, then C10 is 100% eligible for the job offer and claiming Canadian work experience. Okay, it's the self-employed aspect that removes eligibility for Canadian work experience. So keep that in mind. When you're assessing this, that's one of the most important factors. And then the other part of that question, Marianella, what was the other part again?
I think you replied them both.
Okay.
You answered them both, Mark. Yes.
Yeah.
I have a question from Yiting Zhu. To confirm, when applying at the port of entry for C10, we still need to generate the LMIA exemption code for the employer portal first, then bring that in front of the CBSA officer along with all other documents.
Absolutely. You need the A number. Yeah, you have to file and through the employer portal, just like you would with any of the the employer specific work permits. Mm-hmm.
Okay. We have a question from Hossein. This may be a mixed answer between you and me, Mark, but it says, do we need a business plan for the C10?
Okay, so it depends on the circumstances. I'll give you another example. You've got this rock star employee for a U.S. company that, they're a new hire, okay, and they're ideally situated to do the startup for a new presence in Canada. Okay, maybe this person had already worked for another company in Canada, had perfect experience to help this company, enter this particular industry. So the U.S. company or anywhere in the world wants to set up a new subsidiary. So it's a new startup, but this individual hasn't been employed with them for a year. And because they don't have a Canadian presence already, there's no reciprocity, for a reciprocal work permit. So in that case, maybe you can make or attempt to make the C10. And how in the world are you going to justify that when the business doesn't already have a presence? A very good business plan showing exactly how there's going to be Canadians hired. It's going to create opportunities. There's going to be a cash injection. There's going to be a facility that's leased, and you're in a small rural community. You're doing this, right? So those are some examples where absolutely a business plan is critical. And as far as I'm concerned, any type of significant economic benefit that you're trying to demonstrate, at its very heart, there's going to be some form of a plan where you're demonstrating something into the future, where you're projecting it. So the need for a formal business plan, it may not be necessary if the company's already running and you're going to apply for a work permit extension, but I can still see situations where Joorney would help you to map out the adjustments to an existing business plan to show how this person, if they get their work permit extension, is going to continue to benefit and create, these significant economic benefits for Canada. So it's creativity, using all of the tools in your toolbox.
Exactly. And on the business plan side, it's exactly what you were saying, Mark. We focus on explaining what's going to be that hiring plan that is crucial, the job creation, going back to those economic benefits. Also, the significant benefit itself, of course, in the application, it's explained. But here we also emphasize on that. Financial projections are very important. Of course, you're going to see what type of revenue that business is going to have, what expenses are going to be included, what profit is going to be there, taxes are going to be paid. So there's a lot to prove there. So also the industry and market analysis, it's very important. How do you want, you want to talk about why it's important, why Canada needs that person, why Canada needs to elevate that industry, that field. So there are a lot of components on the business plan that would help make that application more solid. So I hope that answered your question, Hussein.
Yeah, and I'll add one other thing to it as well, Marianella. So if you have an officer, put yourself in their shoes. They look at an application where you've included a letter from the employer, which is a critical component, and you've made all of these assertions about how this person is going to create all these jobs and the income that they're going to generate, and you've just listed them in a paragraph. And you've got an application that's presented to you like that. And then you got this other application that has a formal business plan, detailed financials, projections. Like, this is really sophisticated. Which one do you think an officer would be more willing to approve in this kind of challenging area of how do we keep our worker here, when the other avenues are drying up? So that just another another plug for the importance of business plans. It shows that you're serious, that you've thought about this, versus just explaining your analogy to how it's similar to to what they've described in their program delivery instructions. So what you put in is what you get out with these.
And going back to what you said at the start of the webinar, Mark, you said it's very vague and you need to be creative in order to argument that analogy. And I believe the business plan plays a very solid role on that, especially on the economic side.
Yes. Yeah, absolutely. Yeah.
Okay, Mark, people are really excited about the answers because questions keep coming in.
Well, I feel like the answers I'm giving are, your clients are all different and you guys are going to have to be creative, and no two clients are the same. So,
Definitely.
Figure it out, right? Yeah, I don't know how specific my answers are. It's more just getting inside the head of the officer and understanding what tools and resources they have available to them to adjudicate it. And it's really this short little program delivery instruction with these short little vague references to examples or some of the general ideas. And so just because, and I want to reiterate this, just because your situation doesn't really fall within one of the examples that they've described, doesn't mean that you can't create something new that's compelling, like a manager of a tanning salon, right? And so
exactly.
you just don't know, right?
Exactly.
And in fairness, the officer did, it was an officer that I knew. I'll put some context to this. And he did, in that case, I dealt with him on some other matters. He had my email address, and he did send me an email right while he was processing her work permit and said, "Come on, Mark, a C10 for a tanning salon manager." And he said, if it wasn't for how well prepared and supported the application was, it wouldn't have been approved. And I'll tell you, when my back was against the wall, we pulled out every stop possible to show how important she was. So don't just assume that your situation won't work. And also don't just assume that because your company is so large or your employer is just a recognized employer that it's going to be a slam dunk for the C10. It's not. You really, really have to do your part.
Nice. That's great advice. Anu Lal asks, would they normally renew a C11 work permit?
A C11? Well, okay, it's a little bit outside of our topic with C10 today, but understand a C11, just like the preamble says in the program delivery instructions, it's almost seasonal, very, very short term, in and out. So when it comes time to renew, you just have to make the case in the same fashion. Say, look, the business isn't quite where it needs to be. This person needs to stick around a little bit longer. They're in the process of hiring and training a new manager, whatever it might be. And on the self-employed side, once again, it becomes challenging because it's, with references to seasonal and specific reference to it being temporary. Well, why would they emphasize temporary with the C11 when every single work permit is supposed to be temporary? So when they say it, they really mean it.
Mm-hmm. Exactly. We have a question from Rania. Can we use a C10 for a foreign national in Quebec as a visitor to work as a caregiver?
You could make the case. Is there a sufficient social or cultural benefit? Is it? I'm trying to think of a situation. Remember, CAQs are not required for these types of work permits. So it falls into all the other ones that are CAQ exempt. But to use for a caregiver, is there a significant benefit? And can you make the case? So I'm not going to say you can't. Who said, I was going to get a tanning salon manager approved? But really, it just comes down to your argument. You just do the best you can. I think it'd be probably a challenge, but hey, talk about a feather in the cap if you're able to get that approved.
Mohammed Arang. Hi, Mohammed. Thank you for your question. Do Iranian nationals with 5 years of multiple visas, are they able to apply for a C10?
There's no restrictions on anyone applying, right?
Okay.
So unless there's nothing stopping anyone from applying. And even people who have issues, well, it will get refused if you are inadmissible to Canada. So there's no real barrier to submitting the application. It's really genuinely open.
Mark, and just a little note here, we did a poll among people who attended, and we asked if they are currently offering C10 services to their clients.
Yep.
So 33% said yes, 24% said no, and 43% said that they plan to do so in the near future.
Mm-hmm. Yeah.
Just for everybody's reference, which I think is very interesting because
consistent.
we have a nice mix.
Yeah, and I'll add a little bit more context as well. I use C10 rarely, so it's not something that I pull out, every week and explain to the company, oh, let's just use a C10. It's not. The fact situations to align in such a way that I feel confident filing the application, it's quite rare. And when I do file those applications, I'm pretty darn confident it's going to get approved. I don't tend to file frivolous, C10s just to make the company feel like I'm trying to do something for them. I don't. I will push them to an LMIA. I will scour through every possible other option before I ever consider a C10. So.
We have a question from Jawad. A person who is arriving on visitor, would it be an issue at border if the candidate claims for a C10 work permit as he has used a visitor visa, which is an intent to visit in the first place?
Okay, so remember, every time you apply to come to Canada, you have to make sure that the purpose of your entry is legitimate, right? And as a representative, you never want to counsel a client to misrepresent. Now, in your situation, if they have a visitor visa, I'm assuming they've landed and then they're trying to do a flagpole. I would never ever try to request a work permit at the time in which a person is coming in as a visitor. Because what border officers, and I worked as a border officer, what they will say is, you're applying for a work permit, but what did you express your intention as when you were applying for your visitor visa? Did you say you were just coming to holiday, but now you're applying for a work permit? And I've found officers allege misrepresentation in those circumstances, and not only, bar entry, but find misrep and send the person back. So there's no situation where I'd ever use a visitor visa to then apply for a work permit. I will just put a little bit of a qualification on that. During the pandemic, there were crazy things happening. And with the orders in council and the travel restrictions, they were constantly changing. And some individuals that could find themselves at a port of entry because they fit within one of the cohorts that the government was letting in, sometimes we could have them come through under something similar to a visitor entry and then request a work permit right at the port of entry. But those days are long gone. And so going forward, just please understand that you have to, you have to demonstrate the purpose of your entry, and you have to make sure that what you're presenting to an officer doesn't contradict the very essence of the visa that they have.
Thank you. Thank you, Mark. We have a lot of questions. I'm not sure we're going to be able to go through them all, but I'm going to take around 3 more, and then we'll take the questions and maybe share them with you, Mark, and we can answer them directly. Arshin Devji, can a new business application for a C10 to bring in a specialty worker to establish reputation and train the rest of the employees? This is a new business without any proof of concept or proof that they pay their employees. Mm-hmm. Can this new business apply for C10?
Like you said, the more things that fall off of, the things that we're looking at. In other words, the more factors you have an inability to prove, the harder it's going to be successful. So if all of those things you don't have were actually present, the C10 argument would be a whole lot stronger, because your obligation is to demonstrate or prove to the officer that these factors they're looking at exist. that there is a significant economic benefit, or there will be when the person is hired. But it doesn't foreclose the possibility of making the request, right? If you can't get an LMIA because they say, well, we want to see a track record of employing Canadians, which is often the case for LMIAs, to say this person's coming in as a C10 to help kickstart and get things moving, you can make the case. And it's interesting. I guess as I think about these questions, it's kind of fun because the tumblers are rolling in your brain as the questions coming in, and you're trying to think of all these various permutations. Well, could you make an argument that the foreign worker program won't give me an LMIA for this person? I need them critically here because the company hasn't been around long enough. So they're not willing to give me the LMIA right now. So what I want to do is bring them in as a C10, and I'm only asking for a short period of time, whatever it might be, maybe a year. And during that time, because they're here, we will be able to hire Canadians. And this all fits into the phenomenal business plan that Joorney's going to help you create. And you could make that case. Will it be successful? Well, your guess is as good as mine. But if you have no options, realistically, what do you have to lose? That's a good point. Actually, I hadn't thought of that. Whether it's a success, whether it will ultimately be successful, well, I don't know. But hey, creativity, brainstorming.
Exactly. And after what the officer told you, Mark, it's worth the shot to argument and support it as much as possible, right?
Yeah, maybe with that Joorney business plan there, they're like, oh, these guys are serious. Look at all this stuff. Okay, we'll give them the benefit of the doubt. We'll give them a C10 and for 1 year, but don't you be coming back for another one. Get your LMIA, right?
Thank you, Mark. I'm going to take one last question. There are some questions that I skipped because Mark already mentioned them. So don't hesitate to also watch the recording from the beginning, and then you'll get some of those answers as well. We have a question. Is it possible to have ownership and work as an employee for PR transition with C10 work permit?
So is that the same? I think we're once again talking about someone who's self-employed and owns the business. So it's the same answer. If IRCC considers it to be self-employment, then you won't be able to count that work experience. And when you run the business, you have to go through great lengths to show that you are being issued T4s, that you are paid as an employee, and that your position is an actual position within the company, that you have other Canadians that are employed. But they are very, very reticent to grant Canadian work experience when an individual is working for their own company. I've seen it time and time again. In fact, they even alleged misrepresentation for a past client that I had that was transferred from, unfortunately, the immigration consultant who filed the original application passed away, and then it was transferred to me. And yes, he could have done some things different, but the officers alleged that he misrepresented the nature of his work because he didn't list himself as self-employed. And he wasn't able to show the pay slips and the T4s. And in the end, we had to go back and file a leave application and fight off the misrep. And but it took a whole year to fight it off. And by that time, the client said, heck with Canada, I'm heading back to the States. If this is how they treat people. And he actually employed 45 or 50 Canadians in this business that he'd set up. And it was just so you know, anyone who runs their own business and they're 100% shareholder of that business, it's going to be a challenge.
Okay. Thank you very much, Mark. So basically, to conclude, be creative, stick to the analogies, support, provide all the support that you can to argument your case, of course, and add a business plan, right?
Indeed.
Wonderful. So thank you, Mark. I don't know if perhaps you wanna have some closing remarks.
Well, just remember that this C10, the title is we gave this webinar the title "When All Else Fails" for a reason. So don't consider C10 as being this miracle cure to the challenge your client has with securing a work permit. You really, really have to make the case of significant benefit to Canada. And as an immigration consultant, an immigration lawyer, this is what we're trained to do, to help our employers, help our clients navigate their way through this mess. And with a C10, the discretion an officer has works both ways. So that I keep coming back to the tanning salon one because it's the most absurd example. But the only reason that worked is because there weren't this specific enumerated list of things that the officer had to see. Excuse me. The officers have discretion, but with the issuance of the C10s, they have to provide within GCMS a clear explanation of the rationale that they followed to grant that C10, which is not necessarily there for all the other approvals. So the officers are held to a different standard. So you just have to make the case and remember, if it doesn't work out, the default always is an LMIA. And that's it.
Thank you, Mark. And
My
thank you
pleasure.
everyone for coming today. I mean, we know that you're all busy, also including Mark. So we appreciate your time, Mark, and everybody's time being here. Thank you so much.
My
And
pleasure.
until next time.
Okay, take care.
Bye.